Okay.
I do have a question, Your Honor.
Mr. Miller?
Yes, thank you, Your Honor. Would you like us to stand when we speak to the court for an objection, for example?
You do not need to stand.
Thank you.
Mhm. Any other questions?
Your Honor, I do have a question. The court mentioned that you granted requests for remote appearances of witnesses. I know that the State Bar filed such requests. I don't know that Dr. Eastman has filed any requests for remote appearances, although he did indicate in his pretrial statement that some might appear remotely. Is the court only granting the State Bars or also granting the request in the pretrial statement from respondent?
No, any individual, any witness who is seeking, for whom a party would like to make a remote appearance may make that appearance remotely as long as the witness complies with the rules and procedures that I just laid out. Okay?
Understood. Thank you.
And that would be the case not only for the Office of Chief Trial Counsel's witnesses, but also for witnesses that the respondent may seek to call and to have appear remotely as well. Okay. This matter was commenced when the Office of Chief Trial Counsel filed a notice of disciplinary charges on January 26th of 2023. That notice of disciplinary charges, referred to as an NDC, alleges 11 counts of misconduct. Mr. Eastman's counsel filed a response on February 15th of 2023. The parties entered into a brief stipulation of undisputed facts on June the 12th of 2023, pursuant to Rule 5.54 of the Rules of Procedure. And I want to remind parties that evidence that seeks to prove or disprove a stipulated fact is inadmissible. And you can take a look at Rule 5.54B. So the court will not consider any evidence that seeks to prove or to disprove a stipulated fact. This trial is set to proceed today, June 20th through the 23rd, to resume on June the 27th and to go through the 30th. I've already rendered certain rulings with regard to the motions in limine. The Office of Chief Trial Counsel filed 5 motions in limine. The court has granted motion in limine number 1 to exclude the testimony of Professor Royf and the Honorable Janice Rogers Brown. The court granted motion in limine number 2 to exclude the testimony of proposed expert witness Joseph Freed. With regard to motion in limine number 3, the court denied motion in limine number 3, and respondent's expert, Dr. Stanley Young, will be allowed to testify. The motion in limine number 4, the court granted motion in limine number 4 to exclude the testimony of John Valentine. And with regard to motion in limine number 5, the court understood that respondent is not objecting to the limitations that the Office of Chief Trial Counsel sought in motion in limine number 5 with regard to the expert testimony of Professor John Yu. So Professor Yu will be allowed to testify, but is precluded from offering testimony regarding whether it would be frivolous to assert that Vice President Pence should have had the authority to unilaterally adjourn the joint session of Congress, and that respondent's argument that Pence could refuse to count certain electoral votes was non-frivolous. Okay, and so you should have all received the rulings on those motions in limine. The court is aware that the Office of Chief Trial Counsel also submitted a request for judicial notice with regard to, I think it was 334 documents. I will get an order out on that. I can tell you that my tentative is to grant the request for judicial notice with regard to the official government records, with regard to the court records, and the official statements by government officials, including press releases by government agencies. And I am going to take a closer look at some of the public statements and the articles, news articles, blog posts, Twitter posts, et cetera, that the Office of Chief Trial Counsel is seeking judicial notice for, because those are generally not matters that the court will take judicial notice of. Nevertheless, even with regard to those documents that the court will take judicial notice, the court will not determine that by taking judicial notice, that means that those documents would be admissible. So there would still be the hurdle that a party has to establish admissibility, relevance and admissibility of any document that the court has taken judicial notice of or will take judicial notice of. Okay, and let's see, there's one other thing here. Before I go on, would the parties like to address the issues of the request for judicial notice?
Nothing so far, Your Honor, from responding.
Okay,
If the court in its ruling decides not to admit certain things, could the State Bar have an opportunity to address that orally?
yes.
Okay. Thank you.
And counsel for Mr. Eastman would have an opportunity to respond.
Thank you, Your Honor.
Mhm.
Your Honor,
Yes,
I wanted to catch this before it sounds like you were moving on from the motions on limine.
Mhm.
I wanted to say I would like to be heard on motions in limine 2 and 4.
okay, just one second. Okay, Mr. Miller, regarding starting with motion in limine number 2, which was the motion in limine to exclude the testimony of Joseph Freed.
Thank you, Your Honor. My stand at podium.
You may.
Thank you. I may treat both of these motions in limine and the court's ruling together because I think there's some common issues. And if you don't feel that's the case, let me know and interrupt me, and I'll try to be more focused in my remarks. But I'm going to speak to both motion in limine rulings now. On one issue, qualifications may be something separate, and I'll deal with that.
Okay,
In
I
a
was going to
moment.
say that with regard to those two motions in limine, there are some similar but very distinctive issues regarding the qualifications or the lack of qualification of each of those individuals to testify as an expert. So feel free to start where you'd like, and I'll follow up if there's anything additional I need to hear from you about.
Thank you, Your Honor. The court in both of the orders indicated that it felt that the evidence that experts were prepared to offer was, my word, not relevant. And so I wanted to address that with both. In both orders, the court essentially said, because the work that the expert was going to testify about came later than the actions that have been put at issue in this case with respect to Dr. Eastman, that the expert opinion is therefore not relevant. And I'd like to address that. The issue, I think we agree, because the court used the language in both orders about tenability. Tenability is an important issue in this case. And I'm sort of reading between the lines that what the court was saying in both orders is that the expert opinion was not relevant to tenability because the evidence to be offered by the experts came later on. I think one was in 2021 and the other one was in 2022. Because tenability is such an important issue here, it is for the court to decide. I think we're clear on that. And the court, with respect to tenability, determines based on the state of the facts and the state of the law that are presented in the case, whether any reasonable attorney would have thought that that claim or assertions was tenable. And the evidence that goes to the court to inform the court about tenability, again, is an issue of law for the court to decide, is not confined to the evidence or the information that the participant lawyer had. It extends well beyond that. And the reason is that courts in California, since the Sheldon Appel case, as SHELDON-Appel, APPEL, have been clear that it does not matter with respect to the determination of tenability what the speaker or the lawyer actor knew or did not know. That's just not a relevant inquiry. The relevant inquiry is for the trier of fact, Your Honor, to determine whether the action or the statement of the lawyer, actions or the statement of the lawyer was tenable. Would any reasonable lawyer have found that claim to be tenable? There is information that may come after that lawyer acts. For example, any evidence that would go to substantiate the actions that the lawyer took would be information that the court can and should take into account in determining the tenability of that lawyer's actions. Just because that event comes later on doesn't mean that there's some magical cutoff as of the date of the lawyer's actions. And I can think of many examples of that, but I'll cite for the court the Huffstetler case. And that was another California Supreme case that followed Sheldon Appel. And the Huffstetler case, the court made very, very clear that subsequent events, in that case, it was determining whether the initiation of a lawsuit was tenable. And the court in Huffstetler made clear that subsequent to the filing of the lawsuit at question there were certain actions that took place within the case and beyond. And what the Supreme Court said in Huffstetler is that is relevant evidence. It may be that that evidence substantiated the lawyer's original actions. They are filing a lawsuit. And if the substantiation evidence does just that, it supports what the lawyer did in the case, then that is something the court must and need to take into account when determining whether any reasonable lawyer would have found that claim tenable. So going back to Your Honor's rulings, in both Mr. Freed and Mr. Valentine, the court found that because their work and their opinions and the expert opinions that they offered weren't formulated, at least formally, until after the actions with respect to Dr. Eastman, that was not relevant evidence. And
Well,
I think
stop you for just a minute,
Sure.
because that's not entirely accurate. The court did rule on several bases. That's one of them. But first and foremost, as the court pointed out in the order, for example, if you look at the order on motion in limine number 2, is the fact that, is his name, last name pronounced Fried? How do you pronounce his last name?
Freed.
Freed, okay.
Correct, yes.
That Mr. Freed is a certified public accountant.
Yes.
Mr. Freed published an ebook in 2022 that addressed his alleged investigation into what he considered to be anomalies of the 2020 election.
Correct.
In order for Mr. Freed to offer expert opinion and to be designated as an expert, it has to be established that Mr. Freed has some type of specific knowledge, experience, or training about auditing practices, which I understand to be the subject of the primary subject of his expert opinion. But you didn't provide information that reflects that he has Mr. Freed has the type of expertise to offer expert opinion. And so you don't even really get, I did mention the fact that I think that Mr. Freed's book was published in 2022. There's no indication that Mr. Freed, from your designation and the information provided by respondent, that Mr. Freed or that Mr. Eastman had any communications and before some of the actions and the alleged conduct which Mr. Eastman is charged with engaging in, like on January 6th, for example. There is no indication that Mr. Eastman had any communication with, any knowledge about any of Mr. Freed's anomaly audit work that he had done. And so, but first and foremost, I don't see how Mr. Freed is qualified to be an expert.
Mr. Freed's been a licensed CPA since 1980.
He has no, according to what you provided the court, he has no experience in auditing procedures or voting practices.
They are
voting outcomes, which is even more important.
They are statistics, and the undertaking of an accountant or an auditor who is also an accountant is an empirical analysis of data. And that's where Mr. Freed's expertise comes from. He does have very, very specialized expertise. He is looking at raw data from voter rolls.
Tell me when he began to gain this expertise, and if he gained it by education, if he gained it by some sort of special training. How did Mr. Freed gain this expertise that you contend that he has that would qualify him to be an expert?
Well, again, he's a licensed CPA in California. He also has nearly 40 years of auditing experience. And auditors
in voting and election matters?
Not necessarily.
He has no experience in voting or election matters. Audit voting, does he? And don't interrupt me, please. Yes. He has none, does he? At least if he did, you didn't point it out.
He doesn't have any experience in doing audits of raw voter roll information. He undertook that starting in 2021 and ended up writing a book about it in 2022.
Okay,
so
let's move on. Is there anything else that you want to address regarding the court's ruling on motion in limine number 2? And then I'm going to give the Office of Chief Trial Counsel an opportunity to address the issue as well.
Okay, well, I'd like to make an offer of proof with respect to Mr. Freed's expert opinion that I think would deal with the court's ruling with respect to qualifications and also with respect to relevance. So Mr. Freed can testify based on 40 years of experience that in analyzing voter roll raw data, he found, based on his expertise.
Wait, let's be clear. His 40 years of experience is not in the analysis of is not in the does not involve the analysis of raw voter data, does it?
He didn't start looking at
no, I'm asking you specifically the 40 years that you just referred to, because I want us to be very clear.
Yes.
The 40 years of experience has nothing to do with experience in the area of analysis of raw voter data, does it?
It does not, but data is data. These are numbers. These are empirical.
Well, this doesn't seem to be going very well.
What he does is apply an analysis to determine the reliability of that information, just as he would or any auditor would in looking at any other raw data. Financial information is probably the most typical, but there's nothing terribly different about voter roll data in terms of an auditor's role in analyzing it and determining whether or not that information is reliable or there are anomalies that have been identified in that information. It does not take special expertise to do that. It is data in and data out. And he's very qualified to do that work and in fact did that work.
She doesn't seem inclined to grant this
So
for him.
that's
He
the type
did
of,
that work starting in 2021, right?
he did. Yes.
All right, so that does not, in my view, qualify him to have the expertise required to offer the expert opinion testimony that you're seeking. Do you want to move on to the motion in limine? Well, before you move on to motion in limine number 4, I'm going to give the Office of Chief Trial Counsel an opportunity to address the issues you've raised, unless there's something else you want to address regarding motion in limine number 2.
Just on the relevance issue, Your Honor, but if we get back to that, I'm happy to take it up then.
Okay.
Thank you.
Mhm. Okay, Mr. Carling, Mr. Beckerman, Ms. Wang.
I'll do it from here.
Okay.
I do want to address at least one point that Mr. Miller made, and that is regarding his position on tenability being the central issue in this case, which we disagree with. This is not a legal malpractice case. This is a disciplinary case, and Dr. Eastman is charged with ethical violations, including misrepresentations and violation of the law. And for proving misrepresentations, if he made a false statement, we have to show that he either knew it was false or he acted with reckless disregard for the truth. And under that analysis, work that Mr. Freed did subsequent isn't relevant to whether Dr. Eastman knew the statements were false or acted with
His
reckless
client
disregard for
asked
the truth.
him to draw something up,
We also
and he
believe that
did.
his
Like-
opinions as a CPA are irrelevant in this matter, but I'm not inclined to say more about that because I think the court agrees with us on that point. But for reasons essentially the same as what the court said, we don't believe that the opinion of a CPA that states should have followed financial auditing standards is relevant.
Mr. Miller?
Briefly, Your Honor, on the qualification point with respect to Mr. Freed, I was reminded that Mr. Freed has his views have been adopted in the state of Maryland as an auditor with respect to voter roll analysis. So he's clearly been certified as an expert and accepted for his expertise. And the information, again, that he used was looking at the voter roll data, and his opinion with respect to that work and that expertise was accepted by the state of Maryland.
And to what extent do you contend that Mr. Eastman had any knowledge about Mr. Freed's work?
Hi, user
or
has been banned
views,
for naughty words. I thought
when
that
Mr. Eastman
Good Logic was supposed to go live with
engaged in
this,
or
but
is
he
it
hasn't
in
yet.
any of the alleged acts set forth in the notice of disciplinary charges?
Dr. Eastman's knowledge with respect to the issue of tenability is not relevant. That's been the case since Sheldon Appel, which the California Supreme Court made very clear, and it was further supported by the Huffstetler California Supreme Court opinion as well. The court in both those cases made very, very clear that it's not what the lawyer knew or did not know. It's not what the lawyer researched. What the essential inquiry is for the court as the trier of fact, and the court as the determiner of the legal issue of tenability. The essential inquiry is, did the lawyer's actions here, Dr. Eastman, were they tenable? Would any reasonable lawyer find those actions tenable? And it's not limited to what Dr. Eastman knew or didn't know. It does not matter at all that he did not communicate with Mr. Freed until after the alleged actions that have been put at issue in this case. It does not matter at all. The court can look at all of that. It can determine what he considered.
It doesn't really make sense to me what they're charging him with.
Tenability question of law, what came afterwards that may have substantiated or informed the court with respect to the tenability of those actions. And if Your Honor finds that, yes, I believe that a reasonable lawyer would have found those claims and actions and assertions to be tenable, then the state bar cannot discipline a lawyer for advancing tenable positions. So the court has a very wide scope of evidence that it can consider to inform it. It might be decisions, it might be scholarly reviews, it might be journals, it might be debates, it might be legislative actions, and it also may be data that happens to have come later that substantiates the positions and the advocacy of Dr. Eastman. If that's the case, then the court should and must take into account, okay, I see that now. I see that something came later on. And I'm happy to give the court an example of that. So for example, if a lawyer is being challenged for taking a position in a case that didn't have any precedential support, and a year or two later, a court says, we agree.
I'm not sure what you're referring to. This is one of Trump's
information
lawyers.
that the lawyer was advocating about was sustained by a court. Maybe it's an extension of the law. Maybe it's something that is in the same or similar circumstances, but the court would look at that and say, that's important information for me to know. How can a lawyer be found to have not acted responsibly or tenably when the exact position that lawyer was taking was substantiated later on? And there's not any sort of cutoff for the court to consider that evidence. It can look at all of it. And I would think the court would be very interested in the information, whether from an expert or otherwise, that substantiated the advocacy that is at issue in this case with respect to Dr. Eastman. I would think the court would be ravenous to have that information and say, that is helpful for me to know. And that's exactly the situation with Mr. Freed.
So, Mr. Miller, exactly which counts in the notice of disciplinary charges do you contend that Mr. Freed's expert opinions would address?
Any of the counts that discuss, virtually all of them, I think, because if at the heart of Mr. Freed's opinion
is the lawyer that drew some stuff up in regards to what
and Dr. Eastman is being charged in this case.
The vice president was allowed to do regarding the election.
Where it's alleged that Mr. Eastman made certain misrepresentations. The charge is one of violation of Business and Professions Code Section 6106, moral turpitude. The allegations there would seem to go to specific statements made by Mr. Eastman in an article that he wrote. How would Mr. Freed's expert opinion regarding Michigan and what happened in Michigan with regard to what happened there and the statements made by Mr. Eastman be relevant in connection with the expert opinion that would be offered by Mr. Freed?
Correct. I don't think that count 9, at least in the notice of disciplinary charges, captures everything that was said in the American Mind article.
Okay, but the good news for Mr. Eastman is he's not being charged with misconduct for everything he said in that article. He's being charged with very specific statements that were made and which are alleged to have been false. They're alleged to have been misrepresentations. So would you say then that count 9 is not, I understood you to say that all of the counts basically would be relevant in connection with any expert testimony offered by Mr. Freed. So is count 9 not one of those counts?
I read count 9 to have put the American Mind article at issue, but it's not clear what exactly the scope of that conduct is from statements made in the American Mind article. So I'm reading.
The statements are set forward in the count, aren't they?
Well, it says in the article.
Paragraph 68.
Yes, I have that before me. So in the bottom of page 27, The sentence starts at, line 27, page 27. In the article, respondent stated that illegal or fraudulent conduct had occurred during the election, including, and then it lists the subparagraphs A, B, and C. I may argue at some point that they're to be held by allegations for that specific conduct only, but I don't read it that way until I have a ruling from the court that clarifies the scope of count 9. I have to assume that there's other aspects of the American Mind article that have been put at issue here. So that's why I hedge a little bit, Your Honor, because Mr. Freed's opinion about voting anomalies may go to the other portions of the American Mind article. And the court is correct that virtually every other count in the notice of disciplinary charges has at its core some statements or representations or writings with respect to voter anomaly, at least with respect to the factual component of what is at issue in this case. There's a legal component as well, but I'll leave that one for another day.
Okay.
So to be responsive, Your Honor, I do think that virtually every count in the notice of disciplinary charges has some allegation of misstatements or statements without a tenable basis to have been made about voter irregularities and voter anomalies. So in that situation, Mr. Freed's expert opinion with respect to what he found that supports those statements, it would add to the court's information to make the determination of whether those statements were viable, colorable, or tenable.
Okay.
And I would think that Mr. Freed's testimony would be helpful to the court to say, I actually did the study. And although the study came later on in a book, that is information that would be helpful to the court to inform it about the basis for Dr. Eastman's statements that are at issue in this case. I would think that would be essential.
Okay. Mr. Carlin, anything else on motion in limine number 2?
Briefly, just a couple of points. What Mr. Miller was saying about subsequent changes in legal doctrine may be relevant to the tenability of a lawyer's legal theory about something, but we're talking about factual statements in this case and factual misrepresentations about fraud. And subsequent facts are not relevant to what Dr. Eastman knew or should have known at the time. The other thing I'll point out about Mr. Freed, which we established in our motion, is that he never identified any instances of fraud. He said that his observation of anomalies does not indicate that fraud occurred. So, there's other reasons why his opinion would not be relevant or reliable in this case that we set forth in our motion. But I'll submit it on that. Thank you.
Okay, the court's ruling on motion in limine number 2 stands. Motion in limine number 4, Mr. Miller.
Thank you, Your Honor. This has to do with John Valentine. I'm going to say that the ruling was similar. We have a qualification aspect to it, and then we have what I would characterize as a relevance aspect to it. My advocacy with respect to the relevance part of that would be the same as I just made with respect to Mr. Freed. There is no arbitrary cutoff of the information that a court can take into account, Your Honor can take into account with respect to determining the tenability of a lawyer's actions. That's pretty clear. I can quote parts of the Hufstedler case that didn't just look at later precedent, say a court ruling or the highest court in the state actually changing the law that would then support the position that the lawyer had taken earlier. There's a factual component of that as well. And Hufstedler makes very, very clear that the inquiry does not end with the timing of the lawyer's alleged actions. In that case, the Hufstedler court looked very closely at events that took place after the lawyer had filed the lawsuit. Matter of fact, years later. And Huffstedler Court makes very, very clear that that information, subsequent information, subsequent to the filing of a lawsuit, is very important for a court to take into account to determine tenability. There's not some arbitrary cutoff where you say, okay, we can't look at that later on. The court would want to look at that if it assists the court in determining the viability, the tenability of the lawyer's actions. Here, Dr. Eastman. So if there's some subsequent confirmation or substantiation of voter irregularities in a study on that exact issue, that would be information that the court should and has to take into account to determine tenability.
Okay.
And I'm sorry, I didn't mean to interrupt. I didn't know if you were going to continue, Your Honor. So that's the relevance issue with respect to Mr. Valentine. I can explain his work, but it's a similar pattern in that his work did start after, actually his work started before that, but he wasn't in communication with Dr. Eastman. This is just a work that he did, and he has the expertise and the background. He's done this type of work for also decades, and his studies would be important to inform the court with respect to the justification for Dr. Eastman's actions and statements. That's the relevance.
Could you repeat that? His work would...
In this situation, Mr. Valentine's work would go to substantiate the actions and statements made by Dr. Eastman. So if Dr. Eastman says in an American Mind article, there were voting irregularities, there were voting anomalies here, and we've got a study that comes later on, whether...
But what difference does it make if the study comes later on, if the allegations against Mr. Eastman go to statements that Mr. Eastman made earlier on and was not in any way relying on the subsequent study or subsequent investigation? I know, and you don't have to go back over Huffstedler
Yes.
or the Shelby, case again.
Yes.
But do you have anything else to add on that?
Other than that, it's quite clear that's the law in California with respect to
tenability. So that's your issue. That's your point.
To tenability. Right. Yes, correct. Okay. And I think that's the essential inquiry with respect to every charge here. Were Dr. Eastman's actions, were they tenable? Would any lawyer having the same facts have come to the same conclusion? And if any lawyer would have found his actions and statements and advocacy to have arguable tenability, is the phrase that Sheldon Appel uses, arguable tenability, then the lawyer can't be disciplined for taking those actions, which are well within the lawyer's obligation of being a zealous advocate, an obligation to advance their client's interests. And if the principles that they are advancing have a basis in fact and would be found tenable, then charges can't be brought. That would be new law.
Okay, is there anything that you want to add, Mr. Carling?
Well, I previously stated that we disagree that tenability is the central issue in all these charges, but it sounds like that's the same analysis we just went through on the Freed matter. In terms of Valentine, I just want to point out one other position in our motion, which I don't believe the court addressed in the ruling, but Valentine never wouldn't let us look at his database or any of his data. And one point that I didn't make in our motion, but I don't think Mr. Miller will disagree with this, is that our expert, Justin Grimmer, turned over his code and data in his expert file so that anyone could look at it and see how he was running numbers and how he was coming to his analysis. The fact that Mr. Valentine won't let us look at his database or data is by itself a reason to exclude him. But we have the same position on relevance and reliability as set forth in our motion and as related to Mr. Freed.
Yeah, I did note that. Mr. Miller, would you like to address that issue regarding Mr. Valentine's position regarding his database and why that is not a discovery violation?
It's not, Your Honor. It goes to what this database is. I'm not even sure that it's really accurate to call it a database. It's a processing program that is very dynamic, meaning it's not static.
But it's a program upon which Mr. Valentine relied, right? In reaching his opinions?
In part.
So
In
why
part,
shouldn't
it's
it be, why shouldn't it be discoverable and produced?
In the state that it is, it's not something you can simply produce. Here's the code, plug in your own data and run it. It's not a program that works in that fashion. It is a very complex set of algorithms that is being supplemented by data all the time. And it's not something you can simply say, come to my computer, try it yourself and see if something like this works. It's just not what
Well, if it can't be viewed or considered or provided in any format, then what separates it from being speculative or conjecture, which we know is not appropriate basis for an expert opinion?
Sure. Mr. Valentine was examined in detail on the operation of the program. And at no point during the deposition, by the way, was there a request, hey, can we see how your program works? Is there a way we can get access? I think that was sort of suggested at some point through questioning about how does it work? But there was never a request during the deposition to say we need access to this program or this database. It's just not how it works. And Mr. Valentine was very, very clear about how the program is engineered, the type of data that goes into it, and how it operates. And it's something that is shared with clients of Mr. Valentine, and it's constantly being changed and updated. So there was not a neat way to essentially give that ability to anybody to run or to test.
That becomes a problem if his expert opinion is in any way based upon that, whether you want to call it a program or that set of algorithms. Either way, that's problematic. So the court's ruling on motion in limine number 4 stands. Is there anything else that you'd like to address, Mr. Miller?
Not on the motions in limine, Your Honor. Thank you. I
Okay,
appreciate
thank
the
you.
opportunity.
Now, I'd like to take a few minutes to address the issue of witnesses. First and foremost, the Office of Chief Trial Counsel filed a request for exception to the court's orders on witness exclusion. As the parties are aware, the court previously ordered all witnesses who are going to be called during the course of this proceeding to not to access the proceeding before they have been contacted and informed that it's time for them to testify. The Office of Chief Trial Counsel seeks an exception to that with regard to Dr. Matthew Seligman, and request that Dr. Seligman be given an opportunity to observe the testimony of Dr. Eastman, because Dr. Seligman is going to offer certain opinions which address are likely to address Dr. Eastman's analysis and testimony. Mr. Carling, would you like to be heard on that? And then I would like for Mr. Miller to be heard, and specifically with regard to whether or not, if the court's inclined to allow Dr. Seligman to observe the testimony of Dr. Eastman, why it would not also be appropriate to allow respondent's expert witness, Professor John Yu, to also observe Dr. Eastman's testimony for the expert opinion to benefit him in connection with his expert analysis that expert opinion he's going to offer as well. So, Mr. Carling?
Yes. Mr. Seligman, excuse me, Dr. Seligman's opinions are, his opinions about Dr. Eastman's analysis are a central part of his role and value in this case. And Dr. Seligman has read Dr. Eastman's answer and his responses to the investigation letters to understand Dr. Eastman's analysis and views of some of these legal issues. But Dr. Eastman didn't do a deposition in this case. He's not a retained expert in his own case, but he has expertise in these matters. Dr. Seligman sat in on John Yu's deposition. Respondent didn't have an objection to that. John Yu was welcome to sit in on Dr. Seligman's deposition. I don't believe he didn't choose to. But because Dr. Eastman didn't do a deposition in this case, we only have his written statement so far explaining his analysis of these things. And Dr. Seligman should be allowed to address the testimony that Dr. Eastman gives related to these things. Dr. Eastman may expand upon his answer or his written statements or public statements about the vice president's authority and related issues. So it's entirely appropriate for Dr. Seligman to have opinions about the things that Dr. Eastman says in this trial about those issues. And it would be more efficient if he could listen to it and provide his opinions that way. We have no objection to John Yu also listening. I had made that offer to Mr. Miller, and I believe I mentioned it in my declaration to the court. But it was always our understanding that it would be for both experts if they so chose.
Okay, Mr. Miller?
Thank you, Your Honor. The exception under 77 Evidence Code Section 777 is very, very, very limited. The norm is that an expert, or frankly, any witness in a case, is going to be sequestered and not being able to allowed to participate in the proceedings. We obviously have that rule here as well. And now there's an exception being asked for. I don't believe that there should be an exception made in this case with respect to Dr. Seligman. He was deposed.
Or Professor Yu?
It would also be both ways, Your Honor. So either they're both in or they're both out. And we declined to accept the invitation with respect to Dr. Seligman being able to view the proceedings and Professor Yu being able to do the same. Dr. Seligman has been very, very, very involved in this case from the inception. He was retained by OCTC to be an expert way before the NDC was even filed. And I'll have arguments about that role later on, but suffice it to say that he's been extremely inextricably part of the OCTC team on this. We obviously had the opportunity to examine him and listen to his opinions. There'll be more on that later on. Don't believe it serves the purpose of our inquiry here to have Dr. Seligman listen in to Dr. Eastman's testimony. He's had opportunity to look at all the essential information that Dr. Eastman is that issue with respect to Dr. Eastman in this case. I also have a structural issue that I think is problematic, and that is, should the court accept the idea of an exception here? I don't know that I have Professor Yu available to observe Dr. Eastman's testimony. So that's a logistical issue, especially if.
Well, as you might recall, the court had an email forwarded to the parties, I think it was Friday, indicating that the court was considering this request and that the party should be prepared to address the issue today. The reason I point that out is that you had an opportunity to determine whether or not Professor Yu is going to be available. I'm not sure if your uncertainty arises in connection with an inability to contact Professor Yu or what the reason is. But I'll tell you what my concern, well, let me let you finish and I will tell you what my concern is.
Sure, Your Honor, real quickly on that. Yes, we made inquiry to see whether Professor Yu was available today or however long Dr. Eastman's 776 testimony goes, and there's not availability there. So again, I wanted to make the court aware of that's then we won't be able to have this bilaterally. Both sides won't be able to examine or listen to Dr. Eastman's testimony. It'll just be one way, and that's an issue in my mind. So other than that, Your Honor, I don't have anything further with respect to the request for exception, other than the court should deny it.
It generally, witnesses are not allowed to observe the testimony that is offered during the course of a proceeding. I am concerned about denying the request, because the other way that this is often handled is that an expert will have access to, say, a nightly transcript where of the testimony that's given, and the expert will have an opportunity to look at that testimony and can address whether that testimony that came in is actually in line with the expert's understanding as to the underlying issues and facts and the information upon which someone might have relied. That is not possible here. Generally, an expedited transcript can take at least 2 weeks. And so it would not be the best use of anyone's time or resources if we do not allow an expert to hear the testimony of the individual about whose matters that the witness is testifying about will actually give, that testimony. So in the interest of time and more efficient management of the hearing, I'm inclined to allow Dr. Seligman to hear the testimony that Dr. Eastman is going to give, and to make that opportunity available to Professor Yu as well. And I don't know if maybe Professor Yu, I don't know the reasons he's not available. I'm not going to delve into that, but certainly he will have the opportunity. Or is there another expert witness who you think might be a more appropriate expert witness that would be offered by Dr. Eastman to hear Dr. Eastman's that testimony?
If I understand your Honor's question, it is there somebody else that could act as a conduit to get that information?
Not conduit.
Okay.
If there is another witness who is going to testify about the an expert witness about the testimony that you anticipate that Mr. Eastman is going to give, that would be appropriate.
Not anything.
It would appear based on, I'll go back from it. It would appear that based on respondents' expert witness designations and description of the opinions that Professor Yu is going to offer, that would be appropriate for him to be the counter expert, in other words, with regard to those issues, and with regard to the issues that the Office of Chief Trial Counsel has identified as issues that Dr. Seligman is going to testify about.
I think it's a fair characterization to say that Professor Yu is a counter expert to Dr. Seligman. And it's pretty clear that's been the structure of it. It was essentially the way it worked for the discovery phase and depositions. So to answer the court's question, is there somebody else that we would want to designate or be in some way involved in those communications? I don't think so. It would have to be Professor Yu. If this is going to be a structure where both experts testifying about similar subject matter are given opportunity to hear from the respondents' examination, I think it would have to cut both ways, and they both have to have equal access. And I can't assure that with Professor Yu, and I can't come up with any alternative of how to make that happen with that logistical
Is there
issue.
an issue of timing with Professor Yu? In other words, he's available um, access the proceeding at a certain time, but not available at another time, or what is the issue?
I'd have to check further, Your Honor, as to what his schedule is. I know that he was unavailable in this time period, the beginning of the trial. There may be some other time period where he would be. I'm happy at a break to check to see if he has that availability. And maybe there's something that can be done along those lines. I just don't know at this
Okay,
point.
well, the court's inclined to grant the request for Dr. Matthew Seligman to observe Mr. Eastman's testimony. And I would like you to report back. We are going to take a break in just a bit to let the court know, as well as the Office of Chief Trial Counsel, whether or not Professor Yu is going to will become available to hear the same testimony.
In terms of, so what is the commitment in terms of the timing of Dr. Eastman's testimony? I believe he's still going to be OCTC's first witness.
Well, I believe that the Office of Chief Trial Counsel is calling Professor or Dr. Eastman to testify today
Yes,
pursuant to Evidence Code 776. And I understand that he is going to be, based on the witness schedule that was provided by OCTC, that he is actually going to be the first witness called today.
that's my understanding. Yes, Your Honor.
So that could be, anytime. We'll take a lunch break, maybe after lunch, but we'll see if we have any other issues that need to be addressed involving witnesses. So we are really looking at Professor Yu's availability within the next maybe half hour or so through to when we take lunch, which will probably take place sometime around 12:30. And then we'll return at 1:30 and his availability in the afternoon.
I'll do the best I can, Your Honor. Absolutely.
Okay. All right, thank you.
Thank you.
All righty, now I think the other issue regarding witnesses is that I had a chance to review the respondent's offer of proof regarding respondent's witnesses. I noted that there are you identified 7 witnesses who were listed in the pretrial statement as respondent's witnesses who will not testify, will not be called to testify. Let's see here. So I understand, correct me if I'm wrong, but I understand that Dr. Eastman is no longer going to call Kurt Hilbert, Linda Kearns, the Honorable William Lejeune, Douglas Logan, Peter Navarro, Russell J. Ramslin Jr., or Jim Tropus. Is that right?
May I confirm to make sure
Sure.
that Thank you, Your Honor. Conferred with Mr. Mayor, and all that is correct with respect to those witnesses not testifying at the hearing.
Mhm. And then I noted that you've also identified 2 rebuttal witnesses, Ms. Juno and Ms. Honey. And in addition to them, Mr. O'Donnell and Senator Rogers as rebuttal witnesses. You identified okay, so all of the 7 individuals that you identified in your offer that you filed on Friday are individuals who are designated as No, not all of them. So it looks like 4 of them are designated as rebuttal witnesses. The 4 that I just mentioned. And you have 3 designated as non-retained experts. That would be Dr. Briggs, Mr. Cox, and Mr. Finkham. Is that right?
I have a second to
Sure.
confer, Your Honor, to make sure that's exactly right.
Why don't we take a 10-minute break and we'll come back at 11:30. And after that, we will see where we stand with regard to the witnesses and moving forward with Dr. Eastman's testimony. All right. So it's 11:20. Let's return at 11:35. Let's go off the record.
We're off the record, Your Honor.
Thank you.
Yeah, let's go up to court.
I'll leave my laptop, I'll bring everything else. Yes.
I think it was saying I was using the wrong microphone. All right, there we go. We are professionals here, people. So in case you missed it, the court is now on recess, and there has been a update in the Hunter Biden probe. With his taxes, he apparently has accepted a plea deal, according to some things I saw on Twitter. But it isn't clear what it means for the Burisma investigation, so that's interesting. I will see if I can pull up here what I saw about that. Oh, it was an article on Fox. Yeah, I know, evil Fox News had an article about it. So, as you can see here, as I was saying, U.S. Attorney for Delaware, David Wise, said the investigation is ongoing. Interestingly enough, though, you go down here. Hunter's lawyer is trying to say, like, oh, it's now closed. I can find, where was it he said that? Is Hunter's criminal counsel Chris Clark of Clark Smith and Valazer said that with the announcement of 2 agreements between my client Hunter Biden and the United States Attorney's Office for the District of Delaware, it is my understanding that the 5-year investigation into Hunter has resolved. But according to him, the investigation is ongoing. So, like, which is it? They're trying to spin it as best that they can, but you know. And the biggest question is how does this again affect the Burisma investigation? Because that had a lot to do with there being a document, I believe, that the FBI was not wanting to share because they were like, well, it's part of an ongoing investigation, and the assumption was that it had something to do with the Delaware investigation. So, you know, the lawyer is trying to spin it as one way, and the way that he's trying to spin it might not be accurate. So that's interesting. I have to do some things in the background here, but I'm gonna keep this up for when they come back. I'm going to be working on keeping this going even when I have to go into work and being able to shut it down remotely. Because if you do not tune in now, you will not get to. There will simply be no way for you to tune in and watch this because it's not supposed to be on YouTube, is my understanding. The only way that you can join is if you have the link, and I can of course post that in chat here. 1 second. If for some reason podcast ends on go here. Also the Twitter link might even be better. That's where I'm getting it from. Let's see here. And some other news, a search for a missing sub that was diving down to the Titanic. They're still searching for that. Some of the specification was 3 knots, 4 airspace, 1,002 electric thrusters propulsion, 96 hours for crew, 5 flight support. It's a subsea imaging 4K Ray-Fin camera, Teledyne 2D sonar, 40,000 lumens of external light, 2G robotic laser scanners, INS/USBL. I don't know really what that means. It's an integrated technology. They are saying that it likely only has 40 hours of oxygen left. And I think we are about.
Professor Yu.
I do have an update, Your Honor. Professor Yu is available tomorrow from 10 to 11 and 1:30 to 5, essentially.
Hey,
And obviously that would
Fix
be
your
to
system.
observe Dr. Eastman's testimony by Zoom
Right.
or by the link.
Okay, all righty. Well, he can join us then, as will Dr. Seligman, but we're going to go ahead. We can't wait until tomorrow to get started. Unless there is another witness that the Office of Chief Trial Counsel would choose to call before calling Mr. Eastman.
No, we will call Dr. Eastman first.
Okay. All right, thank you.
Thank you. I was going to offer something else before we move off the sequestration issue,
Sure.
and that would be sort of consistent with the efficiency I think the court sees in this process, and that would be to allow Professor Yu to watch Dr. Seligman's testimony, and vice versa, if that's what OCTC desires. It's all transparent, and it seems like if we're going to open it up, let's open it up all ways.
Well, let's be clear. I don't want to say that we're opening it up all the way, because there are a number of other witnesses that each party has identified who the court is not going to grant the opportunity to hear Dr. Eastman's testimony. I have no problem with that. Mr. Carling, Ms. Wang, Mr. Beckerman?
Regarding whether other witnesses would listen?
Not other witnesses, only with regard to Professor Yu. That's, I understand, to be your request, right?
Yeah, Professor Yu and Dr. Seligman can both watch Dr. Eastman's testimony, and then when they testify respectively, the other can watch. That's the proposal. It has nothing to do with any other witnesses that we haven't discussed.
So in other words, Professor Yu and Dr. Seligman would observe the testimony, each one would observe the testimony that the other one will give.
Yes, so here for the
In
words
addition
and things,
to, yeah, in
Sorry.
addition to Professor,
Yeah,
excuse me, to
that-
Dr.
that's the
Eastman.
answer.
Mr. Carling, any objection?
No objection to that, Your Honor. But I'm not sure I understood where we left it with Dr. Seligman listening today to Dr. Eastman.
No, the court is going to grant, I think I said the court's going to grant OCTC's request for Dr. Seligman to observe Dr. Eastman's testimony.
Okay, I didn't know if it was limited to the windows that, I understand the court, thank you.
Okay, and the court will allow Professor Yu to observe Dr. Eastman's testimony as well when he is available to do that. The court will allow Dr. Seligman to observe Professor Yu's testimony and Professor Yu to observe Dr. Seligman's testimony when his testimony is given as well.
I think that's accurate, Your Honor. Thank you.
All right, thank
The
you.
other, I'm sorry.
Sure, go ahead.
The other request that we had was for the character witnesses to be able to watch the proceedings, since they're not fact witnesses.
No. Why? Well, let me ask, why would the character witnesses are called to testify that they have, first of all, that they're aware of the alleged misconduct in the notice of disciplinary charges, and that they are allowed to testify about their knowledge about an attorney's background and character. And to know that that would be based upon that individual character witnesses' experiences and interaction with the respondent. I don't see why that would require the character witness to observe the testimony.
Not necessarily required, Your Honor. I'm not suggesting that, but since an element of character witnesses' testimony would be familiarity with the proceedings or the charges here, this would be the best way to be informed.
It would
about
not. I'll
that.
tell you the best way for a character witness to be informed generally about the allegations against a respondent is to forward a copy of the notice of disciplinary charges. It's a public document, and it's certainly not a problem for a character witness to review the notice of disciplinary charges and to learn about the very specific allegations, not as couched by either party, other than as alleged in the NDC.
Okay, I understand, Your Honor. Thank you. And we've done that, by the way.
And keep in mind that the character witness, each character witness is to have knowledge about the allegations. The character witness is not going to be called to give an opinion as to whether or not the respondent did or did not engage in the alleged misconduct.
Understood completely. That wouldn't be any part of their testimony. It would just be, again, to inform the detail and the nature of the disciplinary proceeding. So then they could say, I'm fully aware of it because I've watched it for the last several days, and I can testify about Dr. Eastman's character even in light of that.
Okay.
That was my request.
I understand. That request is denied.
Thank you, Your Honor.
Okay, anything else, Mr. Miller?
No, Your Honor. I just wanted to be clear on the schedule then. Should we handle that next, and I'll sit down and we can deal with that.
No, we can handle the schedule in just a second. Do you have anything else to add, Mr. Carlin?
Well, I have two other, I think what I would call housekeeping matters that I'd like to bring up before we begin the evidence. May I at least identify those now?
Yes.
Okay. One is that we don't have about 4 of respondents' exhibits. I brought this to Mr. Miller's attention over the weekend.
Which exhibits are you referring to?
We do not have copies of 1010, 1039, 1080, 1165, 1168, and 1169. I will also note that in their offer of proof that they filed on Friday, they referred to an exhibit 1201. I believe our exhibits from them end at 1172. So I don't know if that is a typo or if that suggests that there are 30 or more exhibits that we are also missing. But the 6 that I just identified are on the exhibit record, but they were not in the set that were produced to us.
I understand that respondent provided additional exhibits, I believe this morning.
This morning.
Okay.
Your Honor, I was copied on that request from the court, and I believe it was a different sequence. I believe the court requested 1000 to 1010. We are missing 1010, but we're also missing 1039, 1080, 1165, 1168, and 1169.
Okay, I have the wrong numbers. The Office of Chief Trial Counsel does not have exhibits 1010, 1039, 1165, 1168, 1169.
That's correct, Your Honor, but also 1080 is missing.
1080, okay. Mr. Miller?
May I confer, Your Honor? I think we have
Sure.
some of this solved, but let me make sure I get my numbers correct.
Okay.
1010 is, sorry. That's out. 10 was their distribution. So that's out. 1039 is the.
And just so you know, you're talking about exhibits that's not major, but we can hear what you're saying. So you might want to either whisper or communicate in a way so that others are not able to see.
Thank you, Your Honor. We'll-
There you go. I
Make sure
appreciate that I have 9 viewers right now, which technically is a little bit of a record for me. But however, I've been given unofficial
We're
legal
taking a look at
advice
the
that there
exhibits. I do
could
want to point
be
something out, which I meant to
ramifications.
address
That's why
right
another
after the break, and
person
that is that I'm aware of the fact that
that
there
I know is not currently streaming it because they don't know whether or not there could be some issues. However, in the comments section, I have listed where you can join the broadcast if you wish to continue watching. And I will make sure that I put it in the description as well. I will get that taken care of for you. So I'm sorry about that. I appreciate you for joining. As always, the universe may be wide and vast, and you may feel tiny, but it does take all of us working together to make the kind of world that we want and to make the world a better place. So God bless you, and God bless America. Bye.